Hi, I'm Doug Ray, president and founder of the Wealth Guardians and the Ray Financial Group. Bryce, Payne, and Garrett are not with me today. This is the Wealth Guardians video series on all things pertaining to retirement planning. I have a very special guest for you today. It's Mr. Dennis Toman. Dennis is a practicing elder law and estate planning attorney in Greensboro. Welcome aboard, Dennis.
Very glad to be here, Doug.
Good. Dennis is a University of Wisconsin alum. Are you a cheesehead?
Absolutely.
Good, me too. And he's also a UNC School of Law alumni. Dennis, one of the most common questions we get when people come in to see us is, do I need a trust? Do I need a will? Do I need both?
Yeah, and we hear those same questions too. And really what it starts with is a conversation with the client to find out what's most important to them. Mm-hmm. For a client that, is looking for the simplest way to, pass assets, least expensive, but doesn't make things easier on their family, doesn't offer certain protections that are available with trust planning, that they may choose a will-based plan. Mm-hmm. But for other clients, the trust-based plan is probably going to meet their objectives better.
You know, a lot of people have the misconception that a trust is going to save them on taxes. That's not necessarily true, is it?
No, it does not save on taxes unless we're dealing with, specific types of trust.
Right.
The general revocable living trust is not done for tax-saving purposes. It does help to save some court costs that may be involved with probate, and it is a structure that we can build some of the tax-saving benefits into that trust.
What assets are probatable?
Well, anything that an individual owns in their own name is going to go through probate unless there's a beneficiary tied to it. Mm-hmm. And so a bank account is going to go through probate if it's owned by, let's say we got a husband and wife, and the husband owns a bank account in just their name. If it was jointly owned, it would go automatically to their spouse. If there was a beneficiary on the account, it would go according to the beneficiary. Now, there's a lot of disadvantages to using beneficiaries on bank accounts, but every IRA, every annuity, every life insurance policy is going to have a beneficiary named on that investment or that contract, and so those are not going to go through probate.
Yeah, there was a Supreme Court case years ago that basically said that beneficiary statements trump wills.
Absolutely, to the dismay sometimes of the family. That the situation that has come up in the past is somebody's got a beneficiary designation that they set up maybe when they were married or maybe even when they were single. They're no longer married to that person anymore, but they're still the beneficiary, and they may have changed the will, but the beneficiary is still that person and was still on the account.
Yeah. Well, how often should somebody update their will and trust documents?
Well, they really need to look every 3 to 5 years. Mm-hmm. We actually include that as part of what we do for our families, is say, look, we've got this in place, but we want to encourage you to look at this every 3 to 5 years. It's not that that time is magic. It's the idea that things change. Mm-hmm. Families change, finances change, the health changes quite often. The laws change, and sometimes we just get a better idea. And so the estate plan shouldn't be something that's just put up onto the shelf and never looked at again. It really needs to be reconsidered every 3 to 5 years, or if something else has changed.
What would you consider the biggest estate planning mistake that you see on a daily basis?
The biggest mistake of somebody who actually has an estate plan is that they don't have the right power of attorney in place. Powers of attorney are so critical because they apply during the person's lifetime. And if a person doesn't have that power of attorney in place, then the court's going to order a guardianship. And guardianships are something to be avoided if at all possible. They're adversarial, they're time-consuming, they're expensive, they have a lot of red tape, and very restrictive on the individual. If we can have the right power of attorney in place, probably combined with a trust-based plan quite often, then things are going to go a whole lot better if we're dealing with issues of dementia or Alzheimer's.
Another question we get quite a bit is, if I have to go on Medicaid for care, is the government going to take my house or my assets or whatever?
Yeah, so, there's limited ways to pay for the cost of long-term care. We talk about that quite often. Medicare really doesn't help much more than rehabilitation, maximum of 100 days, usually many less than that. There are some VA benefits available. We talk about those sometimes. The long-term care insurance, if a person has it, critical. They're going to be very glad they've got it in place when the time comes that they need it. Otherwise, really dealing with just private pay or Medicaid.
Mm-hmm.
And private pay, yeah, that's good, but the person could wind up spending all of their money living on $70 a month the rest of their life. Or they might, if it's a married couple, they spend most of the money on the first spouse that needs care. The surviving spouse may find themselves living out of a can of baked beans for the rest of their life, being impoverished.
Yeah. If you're liking what you're hearing today, please click the button below to like and subscribe to our Vault podcast. All right, to sum things up, when does someone need to start planning their estate?
Well, we often talk about the elder care journey.
Mm-hmm.
And, starting with a healthy, vigorous senior, there's traditional estate planning that needs to be done then. When we start to deal with memory or mobility concerns, we talk about diagnosis planning. Don't delay. There's a 5-year look back for some of the government programs. We need to plan ahead. We don't want to lose valuable years of planning time or arrive at a point where the person can no longer make the decisions needed to decide. And then we've got the situation where there's a crisis, one spouse or the other, the individual is going into the nursing home. And so starting now is so critically important.
Well, that pretty much sums it up. Dennis, why don't you give out your contact information if somebody wants to call you up that's listened to this podcast?
Sure. Yeah, we're located at phone number 336-378-1122 or elderlawfirm.com is where you can find us online.
We've got folks that listen to these podcasts all over the country, even the world. What states are you licensed to practice?
Yeah, so everything we talk about is in North Carolina.
Okay. So North Carolina residents, give them a call. Thanks for listening.